Companies Act, Section 241, Application to Tribunal for Relief in Cases of Oppression, Mismanagement, or Prejudicial Conduct. Section 241 of the Companies Act, 2013 provides a statutory remedy for members of a company or the central government to seek redress before the National Company Law Tribunal, NCLT, when the affairs of a company are being conducted in a manner that is oppressive, prejudicial, or detrimental to the interests of the company, its members, or the public. This provision forms a crucial part of corporate law designed to protect minority shareholders, ensure proper corporate governance, and enable government oversight in cases involving fraud, mismanagement, or public harm. It allows members and regulatory authorities to intervene where abuse of power or mismanagement affects the fair and lawful operation of a company. 1. Right of members to apply to the tribunal. Section 241, 1, allows any member of a company to file an application before the tribunal for relief if he/she alleges that a. Oppressive or prejudicial conduct. The affairs of the company have been conducted or are being conducted in a manner prejudicial to public interest, or prejudicial or oppressive to the applicant or any other members, or prejudicial to the interests of the company itself. This includes actions by the majority or those in control of the company that result in unfair treatment, exclusion from management, misuse of company funds, or decisions detrimental to minority shareholders or the company's well-being. B. Material changes in management or control. A material change has occurred in the management or control of the company which is not caused by or in the interest of creditors, including debenture holders, or any class of shareholders. Such a change may be an alteration in the board of directors, a change in the manager, a transfer of ownership in shares, a change in membership, especially for companies without share capital, or any change in any other manner whatsoever. The member must also allege that due to this change, the affairs of the company are likely to be conducted in a manner prejudicial to the interests of the company, its members, or any class of its members. Eligibility condition: the member must satisfy the criteria prescribed under Section 244 to apply under this provision, example, minimum shareholding or number of members required. 2. Power of the central government to apply to the tribunal. Where the central government is of the view that the affairs of the company are being conducted in a manner prejudicial to public interest, it may suo motu, on its own motion, file an application to the tribunal for appropriate orders under this chapter. Jurisdictional provision. The application must be made to the principal bench of the tribunal, in respect of such companies or class of companies as may be prescribed. The principal bench shall handle and dispose of such matters exclusively. This enables the government to act in the broader public interest, particularly in situations involving large corporate entities, essential industries, or companies affecting economic stability. 3. Initiation of proceedings against unfit officers. In addition to addressing oppression or mismanagement, the law empowers the central government to initiate proceedings against individuals responsible for misconduct in the management of the company. The government may refer a case to the tribunal if it believes that any person involved in the conduct or management of a company is guilty of a. Serious misconduct or breach of duty, fraud, misfeasance, persistent negligence, or default in performing statutory duties. Breach of trust with respect to their responsibilities under the law. B. Unsound or imprudent business practices, conducting business not in accordance with sound business principles or prudent commercial practices. C. Damage to industry or trade, management that has caused or is likely to cause serious injury to the interests of trade, industry, or business to which the company relates. D. Fraudulent or malicious intent. Conducting business with intent to defraud creditors, members, or others. operating for unlawful purposes or in a way prejudicial to public interest. In such cases, the government may request that the tribunal conduct an inquiry and determine whether the individual in question is a fit and proper person to hold the office of director or any other managerial position in the company or any other company. 4. Respondent status of the accused. When a case is referred under subsection 3, the individual accused of misconduct must be joined as a respondent in the proceedings before the tribunal. This ensures the individual is given an opportunity to present a defense, subject to judicial scrutiny, not condemned without due process. 5. Format and contents of government application. Every application made by the central government under subsection 3 must a. Include a concise statement. It must provide a clear summary of the facts and circumstances, along with supporting material which the government believes are relevant for the tribunal's inquiry. B. Be signed and verified properly. The application should be signed and verified as per the Code of Civil Procedure, 1908, in the same manner as a plaint in a civil suit. This ensures procedural correctness and legal formality in the referral process, establishing the seriousness of the action being initiated. For more details, contact us.